So we were preparing for this discussion this morning. Peter made it clear to me that he didn't need a very long introduction. He's known to everyone here. So he is on a secondment from Jenner & Block to the UK SFO as International Liaison and Investigations Advisor. And we're going to hear more about that. And the big news in a couple of weeks is not whether the UK leaves the EU, but that Peter is returning to Jenner from the SFO. And so without a sort of further ado, we're going to sort of dig into the questions. One of the key difficulties here is, as it's often the case, the keynote speaker can't really say much that would commit the agency or the administration.
I'm sorry, I can't comment.
So after having said, that you will get no answer and nothing practical, I'm going to put very clear questions to Peter and see how he manages that. But please bear with us. I guess the first issue, which is could be of interest to us here, is the conflicts between different approaches and different rules, different expectations of enforcement authorities. And the SFO has made it, repeatedly said that they want to have the first account of witnesses and so on and so forth. Yet the companies do need to make some kind of assessment as to the facts to advise that client and so forth. And the key concern there is privilege. And in the fight over privilege, and privilege differs depending on each jurisdiction. Is there any sort of pointers or tips? Is the issue of privilege going to be settled for at least this first step of the investigation before the authority is involved, and especially in a sort of a cross-border context?
Well, of course, as everybody who practices this kind of law internationally knows, different countries will have different rules on privilege. I, in the private sector, did some work in China where the rules are quite different from what they are in the United States or what they are here. Let me step back, though, for a minute here when you said the SFO wants the first accounts. That's not exactly right. The lawyers for the defendants, or before they're defendants, the suspects, who American lawyers might think of as targets and defendants, they want the first accounts of the witnesses. And disclosure rules, discovery rules here are a very strong lever for them to get it. The courts, the defense lawyers, view it as fair to those who are going to be put on trial to get first accounts. Now, of course, that then instantly sets up a conflict between two terribly important legal principles. One is the attorney-client privilege in the interviews done of the different witnesses, and the other is the right of the person being accused of a crime to get those. So the law has, at this stage, the current state of the law and what our corporate cooperation guidelines try to do is reflect the balance that needs to be struck, you are permitted to retain privilege over your witness accounts. Now, there is a DPA code, Deferred Prosecution Code of Practice, that was promulgated about a half a decade ago, and it says that a company that seeks to gain credit in asking for a DPA can provide first witness accounts. And that code hasn't been changed in the last 5 years. What if one does not waive, then one is not punished. The SFO does not punish anybody for that, but you don't get the additional credit for deciding to waive. Now, indeed, that's not so different from what happens in the United States, where the Department of Justice will not ask for you to waive, but those practitioners who want extra credit know that they can waive. So I think that there's actually a convergence going on here. What will remain true here, I think, is that the lawyers representing individuals will say, we should be entitled to that. And it is for that reason that a court, when the SFO did a DPA negotiation some time ago, the court said, SFO, you should have done more to try to get those. And so the SFO is requiring, if you are maintaining privilege, which you may, and for which you will not be punished, you just need to give us an assessment from a barrister that indeed is not privileged. In the world of first accounts, that's not that big a deal. It's essentially that it hasn't been waived.
Right. So it's really on the company's. It's for the company to decide whether it wants to waive or not, and whether it has an interest there.
Entirely.
And maybe just a follow-up question there: if a company provides information to the SFO, can the SFO provide some kind of assurance that it won't turn over that information to a foreign authority? That may sort of help the company in its decision to.
I think. I mean, you heard both from the Department of Justice and from the director of the SFO how closely countries are working together, how closely prosecutors are working. I think it would be very difficult to get that kind of an undertaking. And parenthetically, I think most law firms representing companies at this stage know that it is not necessarily smart to try to divide mom against dad.
But mom and dad, UK, US, and this sort of common phrasing. I think one people divided by the same language, right?
Yes, very much.
But of course, there are other authorities out there, and maybe this is a good sort of transition to another question. Is there's been a lot of talk about anti-piling on policies and the fact that sort of double jeopardy in this global world. Part of the punishment for a company is the investigation itself. It has considerable cost and so on. Are you ready to consider? And I mean, the U.S. is a bit of an exception, I think, in this very close relationship that the UK and the US have, including in this area. Is the SFO in the near future, you think, may be comfortable not knowing anything, knowing that something's happening, an investigation's ongoing, and that the company is reporting to its sort of maybe closest authority or one authority where it has its headquarters and so on, and just knowing about the facts at the final, at the very end of the process? Or do you want necessarily frequent updates with all the underlying questions and concerns and legal issues which come with updating everyone at the same time?
I think it would be very difficult for any sovereign to say, oh, we're going to leave it entirely to another nation. And I think that the trend is going to be more international cooperation, more sharing of information as is appropriate, rather than, oh, you just take care of it all by yourself. I think prosecutors around the world will not regard that they had discharged their duty if they just delegated it to somebody else.
So it's really interesting that you use the word sovereign. I think that's the key debate in France, and has been over the past year, where we've seen the rise of populism all over the world, and it's certainly the case in France as well. And there's a trend of thought which is sustained by a large group that these cross-border enforcement and work by enforcement authorities, whether it's DOJ or here the SFO, it's really aiming at the DOJ, is really in the hands of the politician. And it's about influencing and weakening a foreign sovereigns, large corporations and so on and so forth. What would be interesting here is to get a sense of where would you, how do you choose which company you go after once another authority is involved? Or do you sort of not choose, and it's sort of an ad hoc basis? There's some leeway in which companies you want to prosecute or not.
Well, leeway here is constrained by the prosecutor's full code text. And it's not just a matter of, oh, I don't feel like it. We have an intelligence unit that will take information in. We are guided by facts and law. I mean, that really is the lodestone for us, is facts and law. And if there's enough to open a case, and if it's the kind of case that warrants the special skill set of the Serious Fraud Office, we're a little unique in England. US lawyers in the audience have grown up in task forces. And it's common to be sitting with your agents and with your forensic accountants and with your digital experts. That's less common here. And the Serious Fraud Office was created in large degree to put together that series of skill sets and work together. So if, having taken a look at the kinds of facts that are presented to us or that we develop on our own, you heard the director talk the other day about how it is that one of her initiatives is developing proactive cases. When that meets the standard for acceptance by the director, she'll then accept the case, and then the SFO, those multidisciplinary teams, will use the legal tools at their disposal to look at the facts, and when there is a sufficient quantum of evidence, to apply the full code test. It's not a finger in the air kind of process. It is really driven by facts and law.
That's very clear. As we know, there's a DOJ member here at the SFO, and so the cooperation obviously works very well because it's sort of. Do you also have someone from the SFO in Washington?
Not yet.
Oh, now that's a scoop.
No, it's not a scoop. Okay. But needless to say, we have had more than the DOJ. We've had prosecutors from Hong Kong, prosecutors from Singapore. It seems to be a way of each of us learning more about the other systems. And it's so terribly important to understand that as we do cases in parallel. You heard, and I think again, it was the U.S. Attorney and the Director talking about how not understanding parts of our system can paralyze or cripple a case done elsewhere. The Allen case, which was talked about on a panel, testimony was compelled over here. It made its way to a witness in a U.S. case against the people whose testimony was compelled. And that ended up being toxic to that prosecution. We have to understand when the tools that we use every single day can upset something in another country, as they need to understand the same. If we are to share information, if we are to work on cases in parallel, we need to make sure that we really understand each other's systems. And this is where the two nations divided by a common language becomes particularly. We use the same words and it means different things.
That was was that the DOJ listening from? There's a so I mean it's interesting to hear that you suggested it was a very sort of dangerous game to try and play. I think the word was one authority against another, and not being fully transparent with all almost immediately is a hazardous game, if you will. There is once the issue has hit the fan and it's out there and you've made contact with the authorities. There's of course addressing the facts and reporting them if that's the strategy the company wants to choose. I guess the question I have is what mitigation can be put in place? What measures can a company use to try and limit the scope of the investigation, or to avoid the complete Pandora's box effect? If you have a large corporate that's in 50 countries or 100 countries, and there's an issue in 10, 20 countries, if you continue looking, you'll find something everywhere. And so how can we give comfort to the SFO, especially in a cross-border context, that it doesn't, if it were to look further, it would find something because human nature, but it's okay to stop now, or to stop, sort of at a reasonable pace or a reasonable point. What can it do to make amends in a way?
Well, the word that you used is actually the word in our law. We're obligated to follow reasonable lines of inquiry. And a reasonable line of inquiry doesn't mean every possible conceivable line of inquiry. It means reasonable lines of inquiry. Now, in an international corruption case, I think experienced practitioners in this room will have a sense already what is reasonable and what is not. I mean, two things that I have always thought of, both as a prosecutor and as a defense lawyer, is, has this bad practice spread? And you can really think of two different ways. One, think parallel evolution. If this has grown up because of my sales practices in country A, has it similarly grown up because of the same sets of incentives another place? And another way of thinking about it is viral. That is the person that we found here, where else have they been? Where else have other people in that place been? Because bad practices can spread like a virus. So if I were representing a corporation now, I would be saying you really need to figure those kinds of things out, because certainly the prosecutor is going to ask those kinds of questions. And the prosecutor should ask those kinds of questions. It should not just say, oh, we'll take this one little place and regard it as a complete aberration. That will mean looking at the compliance system. It will mean looking at the controls. It will be looking at whether or not the corporate culture, is this, I mean, you can imagine that every pitch at the beginning is, oh, this isn't our fault. This was a rogue employee. And it is sometimes a rogue employee, and it is oftentimes that the incentives weren't set, or the controls weren't tough enough, or the tone from the top wasn't fundamentally strong. And so as you're doing your investigation as a prosecutor, you need to answer those questions. And I would think as you are representing a company, you would ask those same kinds of questions.
I think that makes sense. Maybe just a short follow-up question on that. And in particular for areas or maybe countries or industries which are at particular risk. And we can always, imagine which those are. Is it, so risk is a risk, you can deal with it. If there's a higher risk, you can increase the compliance system to a great extent. If a problem has occurred, does it necessarily mean that the company has not, had the proper controls in place and so on? And to what extent, should companies step out of some areas, some countries, and just out of the risk of something going wrong and the risk of being prosecuted?
In a sense, you are asking the question that a chief compliance officer asks. And here too is an area of huge international convergence. The AFA in France, the Department of Justice in its compliance things, the Ministry of Justice here in the Six Principles. There's huge convergence on compliance programs. All say risk assessment is the very base. Right. You must understand your risk. You must take a look at it. And certainly there are companies who will take a look at an industry or a country or an industry in a country and say, we cannot bear that risk. But what good corporate citizens will be doing is they will be undertaking that risk assessment, particularly because they need to have a printed risk assessment ready at any time to hand to the AFA when the AFA asks for it. So that the work will be being done, and then the question is all of the other questions that go with a compliance program. How do you get from that risk assessment to a program that genuinely prevents the kind of fraud and corruption that you're looking to prevent?
I think that makes sense. Yeah. I don't want to come back. We've had a Brexit fatigue for 2 years, but something's happening in 2 weeks. You're in charge of advising on cross-border cooperation and issues here at the SFO until that occurs for another 2 weeks. Do you have a contingency plan at the SFO? How is that going to happen?
The SFO has been working very hard on Brexit planning, as agencies all over the nation, all over the nations have been. One of the things that we have faith in is that if there is a disruption, and if the current rules become not the rules that we are able to live by, that our law enforcement partners who we spoke to the day before are not going to stop speaking to us the day after. They're not going to stop returning our telephone calls. We will figure out what the new rules are, and people of good faith who are trying to get this job done will, under whatever the new sets of rules are, figure out a way to get it done. Will there be bumps in the road? Of course there may be bumps in the road. But will people who are trying to do this very important mission carry on? They will carry on.
Okay, so it's a word of hope and confidence in whatever's coming.
Well, there
mankind.
there is great comfort in cultures that are committed to the rule of law.
That's a perfect word, I think, to conclude our conversation. Maybe there's a question from the audience, if that's okay with you.
It's fine with me.
Yes.
Except for Mark Beardsworth.
Peter, you've been at the SFO for a year. You've got great experience in the US as a defense practitioner and a prosecutor. What would you advise is the one thing that the SFO could have, should do, that perhaps you saw at the DOJ and you have in the US, but the SFO don't do? I'm thinking of perhaps more robust Queen for a Day rules, more robust plea bargaining. What is the thing that you think the SFO is missing?
Well, I don't think the SFO is missing much. I think that the very good prosecutors and investigators, the new director is building on a wonderful foundation, and she's going to continue to build on that wonderful foundation. The differences, the legal differences, are enormous. And let me give an example of cooperating witnesses. Now, all of the U.S. lawyers here know the way that we do cooperating witnesses. There is a lawyer's proffer, there is a proffer agreement or Queen for a Day, there's a debriefing, there's a cooperation agreement. There's a standard way of doing it. It's all conducted by the team doing the investigation. In England, the rules are different. And when you have somebody who wants to become a cooperating witness or enter into a SOCPA agreement, the Serious Organized Crime Prevention Act agreement, instead of having the team that is doing the case do it, the possible cooperator is sent into what is called a sterile corridor. And people who have little to no knowledge of the team will be doing the debriefing. Now, this came, I am told, because those flipping people some time ago didn't do it fairly. They broke the rules and caused scandals. When you talk to a U.S. practitioner about how it is that a SOCPA agreement is reached, they shake their head and they say the person will never tell the truth that way. Mm-hmm. When you talk to a UK practitioner about the way it's done in the US, they shake their head and they say the person will never tell the truth that way. So I think that the answer is that there is no single way of doing it. We have these different systems. We each operate inside our rules, and it's two societies that are just dedicated to trying to get it right, and we will.
One of the big differences between the US and here in the West is in the treatment of economic crime, that is to say, the company's responsibility for fraud, through vicarious liability, as one of the superior principles, which of course we don't have. And its cause, as we've seen over the last couple of years, huge difficulty for the prosecution of corporates. How should we proceed in this?
I think that a prosecutor takes the law as it's written. And I mean, we are an organization that is dedicated to the law and the way that it's written. So that I think that from the point of view of prosecutions, just simply applying the law, when you have a failure to prevent offense in bribery, you will see those kinds of cases prosecuted. When you need the controlling mind and will, you will see and should see only those cases prosecuted because that's the law. And so I think that there will simply be a divergence in the number of cases that one sees in each of those categories And it's not an accident, it's the way the law is written.
Can I follow up on
Sure.
that? Lisa's predecessor, David Green, frequently banged the drum about making an offence of failing to prevent crime. Is there any appetite for that?
Let me respectfully say that that's above my pay grade.
Maybe one last one. If it was, do we have 1 minute? One last one, if that's okay.
Yeah.
Okay.
With the Cloud Act in the US and the first rules here in the UK, which allow access not just to emails in the US, but any kind of cloud storage system. I just wonder whether the SFO plans to start accessing companies' data on the cloud in the US that way.
Let me answer a little more generically. That is one of the things that we have all seen is the internationalization of crime. And one of the tools for that is the digital world and the clouds. Information flings around the world today in ways that were unimaginable when I started my practice, and it was the world of paper. As the international rules for sharing information have lagged a little bit behind technology. And I think that every prosecutor around the world, to the extent that the law permits them to lawfully get evidence more quickly, will attempt to use the proper tools.
Thank you so much. So